Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Okay. Yes, we are live and we are with you on The Community and the Law, brought to you by BWF Solicitors. Now, this afternoon, I was reading and was trying to find out what it is there is to do to people who are unauthorized immigration advisors. Who are they? What will happen to them if the law catches up with them? The Community and the Law will be addressing this, and our resource person is lawyer Charles Asma, who is coming from the BWF Solicitor Stables. The Community and the Law we're looking at FOREWARNED is FOREARMED, a caution to unlicensed immigration advisors in the UK. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live. This is a community and the law brought to you by BWF Solicitors. Now, this afternoon, what we are asking you is, are you somebody who thinks that, yes, I know a lot about immigration matters, so I can advise people and take something small into my pocket? There's some bad news for you. The bad news is that the UK government is clamping down on this activity. Why would somebody who is helping somebody regularize their stay here in the UK or giving advice for people to do the right thing going to be pursued? The question is asked. The answer is next. In our discussion, that is brought to you by BWF Solicitors, the trusted partners when it comes to the law. They're located fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them and book an appointment on 0208 493 7340 0208 493 7340. Those of you in Ghana, there's an office in Ghana, and you can reach them on 055 589 5959. 055 589 5959. Emergency situations, call BWF Solicitors on 077 127 61884. 077 127 61884. BWF Solicitors, trust them with all your immigration matters, issues of family and the law, issues of property, issues of business development and interpretation, and of course, updates from the Home Office. BWF Solicitors, they speak your language, they know what you want, and definitely give you what you need to have. I mentioned earlier on that this afternoon we are going to look at immigration advisors in the UK who are not licensed. Why is it that if you give immigration advice and you are not licensed, it's a crime? We'll be looking into that. And I am privileged to say that we have dear Charles Asma from BWF Solicitors with us, who's going to lead us into this discussion and open it up so very well for us. Asma, good afternoon.
Good afternoon, Brakoku.
Thank you very much for joining us and welcome to the show.
Thank you.
Well, I believe everybody in the family is doing fine with that nice, wonderful smile. I know you're doing well as well.
Everybody is fine. We are all fine. We thank God for another mercy.
Well, my friend will always say, thank God for small mercies. Everything of that is quite big. Well, thank you very much. And we'll be coming back to you. But, ladies and gentlemen, those of you who have joined us on the various platforms, we are on BWF Solicitors and BWTV, both on Facebook and YouTube. I want to welcome you. Let's see who is here. But housekeeping, if you come in here, like the page, share, and also announce your presence that you are here so I can acknowledge you appropriately. And if you would want to join us later on, you can send a text. You can also call us on the lines when they are active. The text number is 07399 208 and the phone line when it's active is 0208 493 7345. 0208 493 7345. I believe a few people have joined us. Let me welcome them before I go into some of the announcements I have for you and the updates as well. Baron Wahid Abdullah of Camden, you are here. You've started with a question. Yes, that's pretty good. We'll be looking at that. Lawyer Asma is right here and he'll be picking up that question and give you an answer on that. So, yes, my friend, thank you. Ade Taribu announces himself and says good afternoon to everyone. Yes, we'll go on. When you come in, please let me find out and then I will acknowledge you. Let me go, Felicia Annan. Good morning. Really? Where are you calling us from? It's afternoon here in the UK. It's past 4 o'clock. I believe you are somewhere, either China or wherever. Yes, wherever it is. Yes, we take your greeting and say good morning to you as well. We have some updates that we have for you. But first of all, let me go on to this client, Cole, who is quite happy with the services of BWF solicitors. And he says lawyer Francano was very professional during the conduct of this case. He exhibited extreme patience and clarity by thoroughly explaining all matters with simplicity. He was always available to respond to my calls even outside working hours and displayed a sense of hope and empathy towards my concerns. Thank you very much, lawyer Francano. Thank you, Cole says. And I believe that other people who have really enjoyed the kind of professionalism and the warmth of BWF solicitors will give such feedback as well. Thank you. If you want to leave a message for us, you want to give us a review, you can visit us on Google and also on our social media platforms at BWF Solicitors. Or you can call us 0208 493 7340 0023355 is our number to our office in Ghana. And in all emergency situations, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Um, some updates. Higher English language requirement for UK work visas. The Home Office has confirmed that the English language requirement for certain worker routes will be increased to A level standard, that is B2, from January 2026, raising it from the current B1. So A level standard B2 English is coming up for some work visa routes. Do we know all that? Last one. Let me quickly come to you. This is an announcement. We're expecting that we're in October, so November, December, January, and the B2 for most. No, sorry, B1 for most worker routes will be off. What is B2 and who are going to be affected, if you would know?
Right, yes. So we know that most people applying to enter the UK will ordinarily have to write exam. The standard is that it's A1. A1 is equivalent to primary school English reading and writing.
Mhm.
Now we have A2, which is upper primary. We have B1, which is lower secondary or secondary, and we have B2, which is college or upper secondary. And so I'm breaking it down for people to understand what is B, what is A, what is this. So in terms of the competency threshold, A is for primary.
Mhm.
So if there is A1, A2, then A1 will be lower primary, B2 will be A2 will be upper primary up to say primary 6. Then we have B, which is secondary. So lower secondary and upper secondary. If you are in the UK, we say that, for example, second GCSE or year 11, year 10. If you are abroad, we say senior secondary school, and so on and so forth.
Mhm.
Then we have we have the B2. So the B2 will take us to college level, which in some countries will be about to complete your secondary school or second year of secondary school or third year of secondary school. That is senior secondary school. In the UK is A level equivalent, which is college. Then we have C. C is equivalent to degree level. And so if you have degree overseas and you ask for that to be assessed for English language competency, then that will be equated to C. Now, those coming from abroad normally either A1. If you come in and you are applying, we say upgrade it to A2. If you are going for your indefinite, we say B1 and so on and so forth. But now they want to standardize it to A level equivalent, which is B2. What it means is that you should be able to have a high level of appreciation with respect to reading and writing in English language. And so, if you were able to do your A1 so easily, when it's moved to B2, you need a high level of preparation to be able to get through. But it is what it is. And therefore, you may have to check whether you meet the exemption threshold to be able to be exempted from this. And remember, the government in the past said that most people who come in family life and the family route or skilled worker route dependent will have to move up to the ladder in terms of move up the ladder in terms of their English language competency. And that is what the government has intimated that from January 2026, it's going to be B2.
So you need a higher sense of appreciation of life in the UK, how to communicate, how to integrate properly, and all that. It said a certain worker routes. So does it mean that it's going to affect health workers who are coming from abroad, the religious professionals who are coming in, teachers, and all the other bits? Does the new requirement affect these ones that I've mentioned, or would you be able to tell us which ones may be affected?
Well, we know that before you had to have the IELTS up to a certain level, but now it's been standardized to B2. It says certain worker routes, but most of these worker routes are the skilled workers that we know.
Mhm.
And uh, it says certain because some workers may not necessarily require English language because of the nature of the work. For example, you are coming in as a domestic servant of a diplomat.
Mhm.
You wouldn't have to go through that. But if you are coming on a sponsorship to work for a mainstream employer, as we know it to be, then of course you have to show that you have literacy threshold. You have reached that literacy threshold, reading, writing, speaking, and listening for the work visa categories. But we also know that now that is being moved to B2 for work visa categories, family members who joined their spouses in the UK and had to only do A1, I'm sure that is also going to change in no time. But I should say that nobody should panic because if you really, really, really want to, then with a little practice, you'll be able to pass the exams. It's reading, writing, speaking, listening, and most of the time it's based on functionality of your ability to express yourself. For example, you may be given a scenario and in question will be asked around it. Your ability to answer the question will show that you can understand and you can speak. Your ability to write certain things and so on and so forth. And most people will prepare, and once you go through it, you achieve it. So it shouldn't put people off. It should, but rather it should encourage people to upskill themselves to become more literate and enhance their English appreciation and to be able to um, compete properly within the UK, especially when it comes to expressing yourself once you have entered the UK.
Right. Thank you very much. So that is one of the updates I have for you this afternoon, this week. The next one is the duration of stay under graduate route is reduced to 18 months. The graduate route visa is being reduced to 18 months. This will apply to applications submitted on or after January 2027, with PhD graduates continuing to receive 3 years of leave. As you may know, the if you complete your postgraduate course here in the UK, you are given 2 years to find your level, and now it's going to be reduced to 18 months from January 2027. But lawyer is saying that if you applied before the 1st of January 2027, it will not affect you. Clarify that for us if you may.
To be honestly, I'm pleased. I'm pleased with this piece of news.
Mm,
The reason is that I thought it's going to be sooner. That if you are applying, if you don't do it maybe before January next year, it's going to affect. But I can see that Those who will be affected will be people who will not complete their course until 2027.
Mm.
So if you are completing your course in 2025, you are fine. If you are completing your course in 2026, you are fine. And therefore, such 1.5 or 1 year grace period is good for brothers and sisters who are seeking to extend their stay in the UK on the basis of the graduate visa opportunities available. Yes, so for me, I'm happy. I'm happy that it wasn't made up to or maybe from January 2026, but rather January 2027.
Well, somebody asked me an interesting question earlier on in the that if I came to study here in the UK, I did my first degree possibly for 3 years. I've had my postgraduate study another year. I've been given 2 years to find my level. I spent that 2 years. It comes up to 5 years. These 5 years, do they count up to having your indefinite leave to remain here in the UK?
Did you say the person is adding PSW, post study visa?
Say that again. Sorry, we missed it.
Is that you gave a litany of things
Yeah.
or items? Did you include post study in that list on that
Yeah,
list?
so I said I did my undergraduate, I did my postgraduate and postgraduate study, which is the 2 years that is going to be reduced to 18 months after the 1st of January 2027. So what I'm
Good.
looking at, or the question is,
It's
these
clearer now.
years from the undergraduate to the post study and beyond, do they count up to 5 years that qualifies me for an indefinite leave to remain here in the UK?
It's clearer now. Student visas are never up to 5 years. Student visas up to, depending on the category, it's mainly the case that 10 years continuous residence.
Hmm.
But such continuous residence does not include visa on the work experience category. Work experience category is the 2 years post study.
Okay.
So if you are counting your 10 years residence in the UK on the basis of studies, you always have to remove the post study visa that was given to you.
Okay. All right. That's clear. Thank you very much. So those of you who were uh, uh, throwing that question at me, I've had an answer for you. Thank you so very much, lawyer. So yes, that's what we have as a way of update. So let's look at our nugget, the piece of information that will give you in the week to help you understand certain situations and updates from the Home Office as far as our immigration situations are concerned. Now, this week, we're looking at the question: what is genuine intention to visit the UK in UK visa application? If you'd realize that when you're completing the application, the preambles, the questions, and all the bits that are asked you, there's this bit of genuine intention to visit the UK. What is it? It's a requirement for leave to enter the UK as a visitor that the applicant has a genuine intention to visit the UK. The operative word here is visit the UK. Now, a genuine intention to visit essentially means that an applicant will leave the UK at the end of their visit, that they do not intend to visit the UK so frequently that they are living in the UK, and that they are genuinely seeking entry for a purpose that is permitted by the visa routes or making the UK their main home. They must have sufficient funds to cover all reasonable costs. This one is from RSA versus the Secretary of State for the Home Department, Judicial Review 2024. Lawyer, genuine intention to visit. And I mentioned, for me, the operative word here is visit. So if you're not coming to visit and for another purpose, then this might go against you. Am I right?
Good. So that's the context. Now let's break it down. Somebody will say, well, if I'm here and I haven't left, I'm still a visitor. Now, if you visit somebody and you are not part of that family, you will leave within a day or two, right?
Yeah.
Give and take 1 month you have to leave. Otherwise, even the family gets fed up with you.
Obviously,
Yes,
if you overstay, you're welcome.
you have overstayed your welcome. and it now appears as though you didn't come to visit. That's the context. Now let's juxtapose that to the nugget.
Mhm.
So if we look at paragraph V 4.2 of Appendix Visitor to the immigration rules, it says that the visitor must one, visit for a short period, should not be frequently coming in, and should not be overstaying.
Mhm.
So as that's why we gave the first example, the context. So if you come in with 6 month visa, and when you were coming to the UK, you were asked how long do you want to stay in the UK? Most people, because they are at that stage, trying to be the best of angels, they
Mhm.
will say, oh, they will say 4 weeks, sometimes 6 weeks, sometimes 8 weeks. Oh, I'm just going, I'll come back, isn't it?
Yeah.
You are given 6 months. Multiple doesn't mean that you have to stay till 6 months. Multiple means you can go and come back.
Okay.
Now, you are given 6 months and you stay up to 6 months. Are you living as a visitor, or you are now over? You are now exceeding your limit as a visitor.
Now, they gave you 6 months multiple, expecting that you come in the time probably that you stated on your application, say 4 weeks, and then you have the opportunity to come in until the 6 months is over and your visa would expire, and you stay 6 months in one stretch. Then obviously you haven't told them the truth, have you?
So that is one. But then it then appears that you didn't intend to visit after all. You intended to stay
To
actually,
stay. Hmm.
but you used that as a decoy to get in. That
Hmm.
is one. Another one, you've been given 6 months. You come 4 weeks, you go. You come again 4 weeks, you go. Within that 6 months, you've been coming in 6 times.
You
Are
have been
you coming as
attempting
a
you have
visitor,
simply
or you are now
viewing
coming
rather
to
than
live with us?
visiting.
Are you now living with us, or you are visiting us?
Visiting and living with us, really.
But if we strike the conversation, it will appear that you are
Appear
living.
that this is where you want to be within that 6 months rather than coming in for a short period and going back.
That's why I started with, if you go to somebody's home and you are not careful, they may say that you have become a family member, even though you are not.
Hmm.
And you get, I mean, and so the same context here. So the caseworker wants to see you as a visitor. And so
Ah,
when you are applying, they want to know whether you are a genuine visitor.
okay.
A genuine visitor from the outset, that you intend to enter the UK and leave. So they want to know what you are doing in your home country. That will make you go back. And two, what you are entering the UK to do. That is so necessary that you have to be there. Are you visiting family? Are you for medical treatment? What is it? Or for general tourism? And where is the accommodation arrangement? How long do you intend to stay? That's what they ask you. How long do you want to stay? And so, if after first attempt you keep coming in because you have what do you call it, multiple visa, then your frequent visit to the UK will undermine the genuineness of your intention.
Hmm. Okay.
That's point one. Point two, if you say you are coming to stay for, let's say, 1 month, and you end up staying for 3 months, then the intention you declared has not been lived up. That's another one.
Another one. Okay.
And so, if you look at the nugget, it tells you certain things that will bring into question the genuineness of the person's desire to visit. And
Okay.
so, in this judicial review case of Eze, the court had to decide whether Eze was genuinely visiting the UK, or was using visitor's visa as a way to get to the UK.
Mm.
And the court looked at those factors and concluded that on that basis, there is no genuine intention to visit.
Well, Then it brings me to the scenario that obviously I'll put it across, but I won't ask a lawyer to answer. I want you out there to help me look at this. We're talking about Abba Mansa, who is a prominent real estate developer in Ghana with properties in the UK and two children in boarding school. She made frequent visits to the UK, sometimes staying for 90 days at a time. She had a multiple visit visa for 5 years, which meant she could visit the UK at any time. In the last year alone, she visited 9 times, staying for over 30 days on some occasions. On her last visit, she was stopped at the Heathrow airport and her visa was cancelled. Well, obviously, it will raise a lot of eyebrows, and we'll be asking what could be the reason for the cancellation of her visa. Could it be that she travels to the UK too frequently? Could it be that because of her extensive stay of several months on her visits, she is not a genuine visitor? Or could it also be because she's likely to stay permanently in the UK? So this our friend has a 5-year multi-visit visa. She is a prominent real estate developer in Ghana with properties in the UK, and of course, two children in modern school. So she has reason to be here, doesn't she? It is said that she made frequent visits to the UK, sometimes staying for 90 days at a time. She had a multiple visa for 5 years, which I've stated already, which meant she could visit the UK at any time. In the last year alone, I said she visited 9 times, staying for over 30 days on some occasions. And on her last visit, really, she was stopped at Heathrow Airport and they cancelled her visa. Why? So I'm asking you, what could be the reason? I've given you three scenarios and options. The visa was cancelled because she travels to the UK too frequently. Could it be that the visa was cancelled because of an extensive stay of several months on her visits, which means that she's not a genuine visitor? Or could it be that she is likely to stay in the UK permanently, so they will cancel the visitor's visa? What would the answers be? I'll come back for that. But in the meantime, let's say thank you to BWF Solicitors, our trusted partners when it comes to the law, for bringing us here and giving us the opportunity to have the community in the law, and also to say thank you to lawyer Charles Osman for making it for us. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Am I close to being in trouble? I don't think so, because I am not giving immigration advice, but I'm coordinating that. I'm doing that with um, licensed solicitors and personnel who can give that. Forewarned is forearmed. A caution to unlicensed immigration advisors here in the UK is our topic this afternoon. I would want you to pay particular attention because whatever it is that we bring up and discuss on this program is of concern to the community, the Home Office, and to us as an organization. Why is it that people are not allowed to give advice when it comes to immigration? Loyasma, good afternoon once again, and thank you for joining us. I would read through the question directly at you and say, why is this so? Why are you warning us now?
Thank you very much. Yeah, I'm sure someone will say, "Why is this a thesis statement? For one is forearmed, or this person is what is he up to?" Well, this is for pocket lawyers to take note.
Hmm.
Pocket lawyers. Somebody will say, "Who is a pocket lawyer? A lawyer with a pocket or what?" Right. So all those who are not licensed to offer immigration advice in the UK must take note of this. There are keywords that we want to look at. But before that, we say a very good afternoon to viewers and listeners for making time once again to be with us and to participate in this conversation. So, we have keywords to take note of as far as this conversation is concerned.
Mhm.
The first keyword is advice, advising, advisor, the same thing. Can be an advisor, advising people, and so on and so forth. And we also have arranger, arrangement, arranging. And we also have referral, referring, or referee. Now, these keywords are important because they help to understand this conversation much better. And so, in terms of advice, you give advice when you tell the person the merit of the issue for them to make a decision that is acceptable within the law.
Mm.
And so, if you cannot understand the law or you are not authorized, then the advice you give may put the person at risk. And so, you just have to couch your advice carefully. So, the moment you are advising, then the person is relying on whatever you are saying to make a decision because you become an expert. So, that's advice. Arranger, arrangement, arranging. That's the second word or keyword. To arrange is to put in place the necessary processes for somebody to take it up. So if I want to arrange this program, I will coordinate, but I may not necessarily be the expert to give to deliver the topic.
Mhm.
So I will be working behind the scenes. And therefore, my job will not be different from anybody who has common sense. We are not saying that those who are not the experts or who are not experts don't have common sense. But the difference is that if you are just arranging, you are not putting yourself at risk because you are not giving any expectation to anybody. So arranging. So I can say that, right, I know somebody who understands this, and so please speak to the person. And I can give you the person's details. I can give you the person's address. And I can even find out from the person when it will be suitable for you to see the person for advice. I'm arranging, and that's fine, isn't it?
Okay.
Right. I don't need any technical qualification or license to be able to do that.
Okay.
Then the next one is referral, referee, referring, similar to arranging. But with referring, you're only telling the person that go and see A. With arranging, you put in place the necessary opportunities for the person to be able to meet A. But arranging and referring are similar. So we are looking at immigration in the UK, which borders on people's visas, people's settlement, people's nationality.
Mm-hmm.
That's immigration advice. Now, because it borders on people's sentiment and there's high level of expectation, it's become a protected or regulated activity in the UK.
Okay.
And the regulator is the Office for Immigration Services Commission.
Oh,
Office for Immigration Services Commission regulates that immigration service activity. And the regulator expects that those who offer such service
mm-hmm.
are qualified enough so that they don't put the public at risk. Because most people who seek immigration support are vulnerable.
Yeah.
And so they feed into any information. And so if you don't have the right information, you are putting those people at risk. And so the regulator has said that government should come up with law to regulate that service. And so under the Immigration and Asylum Act of 1999, the government through parliament
Mm-hmm.
came up with law to ensure that those who are not authorized cannot offer the service
Okay.
so that people are not put at risk. So, once we give the categories of people who are required to give that service, then anybody else outside that list is not authorized.
Okay.
And this will be for that person.
Okay.
Because there's consequence for offering that service without authorization. And the consequence is within Section 91 of the Immigration Asylum Act of 1999. And so we are going to humbly request producer to offer us the context of this conversation, the resource. Producer.
So we're going to the resource, and as lawyer said, you would have to be authorized by the OISC. And also, if you would not fall foul of the law, then you would probably just be an arranger, a referrer to the person that is so qualified and licensed to do so. If you find yourself outside this category and this bracket, then when you offer any help, support, you are likely going to be falling foul of the law. And it's taking us to the Immigration and Asylum Act of 1999. I want to remind you that if you have any question, you can text it to 0739920848, or you can wait till the lines are active. You can call 0208 493 7345, or leave it in the comment section below. Now let's go to our resource.
Yes, so we look at section 91. Please read the preamble for us. Someone may say, oh, but 1999 is old. Maybe the law doesn't even bite any longer. Read the
Well, it says
preamble,
changes
changes to
legislation.
legislation.
Yeah, Immigration and Asylum Act 1999, Section 91 is up to date with all the changes known to be in force on or before the 18th of October, which is today, 2025. There are changes that may be brought into force at a future date. Changes that have been made appear in the content and are referenced with annotations. So we're going to look at the changes, the offenses, and the rest of the lawyer.
Right. So let's look at the regulator's expectation. The regulator expects that individuals who offer such services are people who are trained enough
Mhm.
to be able to use the law to advise and create expectations for the public.
All right.
And so the advice will be one that is couched in law.
Okay.
And so the person will be cautioned or will be um, put on notice that these are the consequences of this type of application. If you are refused, this is what's going to happen. If you, and therefore this is what you need to do and all that. So the person is advising on the basis that they are following the rules. People who are not licensed or trained to be able to do that will do it anyhow. And that's why most people call them pocket lawyers, because they are doing it based on what they think it is or based on their own experience, not necessarily based on the law. Now, the regulators, we have the Immigration Office for Immigration Services Commission. We also have the SRA that deals with solicitors. We also have the Bar Council that deals with barristers. We also have the Silence Group, that is the Chartered Institute of Legal Executives body that deals with individuals who are chartered legal executives. So you can see that we've mentioned about four categories of qualifications.
Mhm.
One, you are a qualified lawyer, licensed to offer a range of legal services, including immigration. One, you are a solicitor qualified and you have been admitted to the role of solicitors, and your work or advice is regulated by the Solicitors Regulatory Authority and also by the Law Society. Or you are a barrister called to the bar in the UK, or if you are a foreign qualified, you have been accepted to practice in the UK in that area of immigration service, and that your work is, again, your conduct and work and everything is regulated by the Bar Council, and you follow certain benchmark or standard. We also have the SILEX group, Chartered Institute of Legal Executives, and therefore, if you have SILEX accreditation, either part qualified or fully qualified SILEX executive, then you also have the authority to offer immigration service, including advice. And we come to the range of service.
Okay.
Again, we have people who are not lawyers, but they have specific interest in immigration service. And so they have license by the Office for Immigration Service Commissioner to be able to offer immigration advice, what we call OISC practitioners. So OISC practitioners may not be lawyers, qualified lawyers, but they are qualified to offer immigration advice. So these are the four categories of people in the UK who can offer advice. So if anybody say, oh, I can do this for you, I can do that for you, or approaches you that I'm going to do ABC, question is the person a solicitor? Is the person a barrister? Is the person has the person got a license by the Immigration Office for Immigration Services Commissioner, OISC, or is the person a SILEX practitioner?
Then I'll ask the question. You know, there are several areas of law, and immigration is one aspect of it. Does a person who has qualified generally as a lawyer be qualified to give immigration advice, or may have to apply to the OISC before they can give immigration advice?
So if you are a qualified practitioner,
Mhm,
i.e., a solicitor or a barrister or a SILEX executive in the UK,
mhm.
presumption is that you understand the law to be able to use the law to advise.
Okay.
And so even if you are not practicing in that area of law, because you are trained to understand the law, presumption is that you can advise properly.
Okay. So then also our understanding should be any lawyer, if there's an expression like that, would want to deal or give immigration advice, and they should apply to the OISC for them to verify and attest that the person can give proper advice before they can do that. Would that be correct?
Right. So we've talked about four categories.
Hmm.
So if you don't want to be a practitioner of law,
Okay.
you just want to specifically deal with immigration advice and support,
Hmm.
then go and get a license to deal with specific immigration work. And the
Okay.
license will come from the Office for Immigration Services Commissioner. So you can have level one, level two, level three license to practice. You are
Okay.
okay. Level one, you only give basic advice. Level two, you do casework in addition. And level three, you can do representation at appeal court when it comes
Oh,
to immigration appeals.
okay. All right. So then um,
Hold on,
immigration
hold on.
advice. You have.
Let me. I put in an expression. I have to qualify it. I
Mhm.
say appeal court. I don't mean the structure, the court called appeal court. I mean to
Okay.
deal with immigration appeals.
Okay. To do with immigration appeals. Well,
Yes, that's what
thank
I
you
was.
very much for that
Otherwise,
clarification.
appeal court. Hang on, no appeal court. It's immigration appeals.
Well, thank you very much. Well, that's what you get from BWF solicitors. They give you the code and then the correct one. So you don't go out and say, well, this is what the lawyer said. We give you the correct one. Thank you very much. And that's also another benefit of this program, the community and the law. And remember, it's brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, as you may have heard, we are looking at a caution to unlicensed immigration advisors in the UK. Lawyer Charles Asma from BWF Solicitors has outlined who can do that and who also authorizes people to do that if you are not a practicing lawyer but you want to support immigration situations and also give immigration advice. You can fall foul of the law if you are not licensed. The discussion continues, but I want to remind you that we're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. These are social media handles. Welcome back and thank you for sticking around. Make your presence felt and known in the comment section down below at BWF Solicitors at BWTV UK, both on Facebook and YouTube. Lawyer Charles Asma is here with us and he is taking us through the caution for warned and forearmed, the consequences of giving immigration advice when you are not so regulated to do so. That's one. Let's go move on to the next step of our discussion this afternoon.
Sure, yes. So we look at, now that we know who is qualified to do this and who regulates the industry,
Mhm.
let's look at, and so what? What is the warning here? So we go to section 91. Please read section 91 for us. Rakuku. The offenses.
91 talks about offenses. And it goes on one to say a person who provides immigration advice or immigration services in contravention of Section 84 or of a restraining order is guilty of an offense and liable A, on summary conviction, to imprisonment for a term not exceeding 6 months, or to a fine not exceeding the statutory maximum, or to both, or B, on conviction on indictment, to imprisonment for a term not exceeding 2 years, or to a fine, or to both. So that is the first one.
Yes. So before we go to number two,
Mhm,
Rakuku, you realize that section 91.1 makes a reference to something. There's a signpost, right?
mhm.
What's the signpost section?
Now it says
It's referring out to another section, right?
Section 84
Good.
or of a restraining order.
So section 84 tells who qualifies. And
Okay,
sometimes, so there is, so I'm going to explain the restraining order part. Then we'll go to section 84 to look at the specific individuals the law is talking about. It says that
okay,
a person who provides such immigration advice or services in contravention of 84 or a restraining order. So a restraining order is for somebody who qualified, but due to some behavior has been banned from doing so for a while.
okay,
So if you are banned or barred from doing so and you do it, then you fall foul under 91.1 because you have a restraining order against you.
okay,
So it can be a lawyer, it can be an OIC practitioner, it can be a SALES practitioner, a solicitor, barrister, SALES practitioner, or OIC license holder. And due to something, you have been prevented from delivering the service for, let's say, a certain period or forever, and you do it, you fall foul under 1.1. You become as useless, or you fall. Then, when you have a restraining order against you on that particular grounds, then you are you are in the same category as somebody who is not qualified.
okay,
Yeah. So somebody who is qualified but is prevented from doing so cannot do it. Now, somebody who is qualified is 84. So, producer, go to 84. Just go back to the table of content. Take us to 84 to set the context for this. No, go back to the table of content.
table of
Yeah,
content on the
table
top.
of content on top left. Then
Yeah.
scroll down to 84. Table of content.
So this one is talking about Asylum Act of 1999, and we're
84.
looking at 84. So
Yeah,
quickly skimming through provision of immigration services. And
exactly.
this one talks about, well, the preamble is talking about the changes on or before the 17th of October 2025. Now, provision of immigration services. Number one, no person may provide immigration advice or immigration services unless he is a qualified person. So he goes on to the annotation F1 and this point two. A person is qualified person if he is a registered person authorized by a designated professional body to practice as a member of the profession whose members body regulate. And BA says a person authorized to provide immigration advice or immigration services by a designated qualified regulator. Um, I think maybe for our purposes, we'll read on and we say, or acting on behalf of and under the supervision of a person waiving any of the paragraphs A to BA with the annotation F5, whether or not under a contract of employment.
Good. So here, let's clarify. What do we mean by under supervision or acting on behalf of?
Mhm.
So, when you go to Citizens Advice Bureau, they offer immigration support.
Yeah.
When you go to the council sometimes will say that if you are making your immigration application, come, we'll review your application for you, right?
Mm-hmm.
But that's also immigration service, and that's council. So there are some people who are within the rules allowed to give such limited support and advice. Citizens Advice Bureau and the councils.
Mm-hmm.
Now, there's also within the categories of the people who have been itemized at the top: solicitors, barristers, SALES practitioners, and OIC practitioners, who are operating with individuals who are not themselves qualified.
Okay.
In that case, such people who are not themselves qualified will be acting on behalf of the ones who are qualified. True or false?
It's true.
True. And that is the E. Yeah. 2E. 84 2E says that acting on behalf of and
Mm-hmm.
under the supervision of a person within any of the paragraphs listed above. So if
Right.
you come to BWF solicitors, for example, there are other case workers who work with the lawyers. We
Mm-hmm.
have trainee solicitors, we have solicitors, we have senior partner, we have case workers.
Right.
Case workers may not necessarily fall under the categories above, but they act on behalf of the categories above and the
Okay.
supervision, and therefore they are covered under 84.
Okay.
And so, if you are not supervised or acting on behalf of any of the people above, and you are doing it anyhow on your own, then you don't qualify, you don't come under 84. Then you will fall foul of the law. That is what I wanted to clarify.
Now, with this clarification, just before we go on, if, for instance, I provide support in any shape or form, but I act as somebody who has been kind of commissioned by a licensed person, even though I will not be operating within the same office premises of that person or that unit, would I be classified under 84 uh, 2E?
Let's give example, and I'm going to use examples known to us.
Okay.
Ragoku, you work with BWF solicitors,
Yes.
and sometimes people will come to you to say that, can you explain this? Can you clarify that?
Yeah.
Now, when you are advising or responding to that, that response is advice. It's immigration advice.
Yeah.
When you are responding in your capacity as somebody who works, the question, in what capacity do you work? And at that point, were you giving on behalf of, or you
Mhm.
were giving under supervision?
How do we prove that?
But how do you prove that? So, looking at you yourself, for example, it may be the case that yes, you work with the team, but any support or advice you are giving may not necessarily be on behalf of the team, or you are not under supervision to give per se.
Right.
And so sometimes you say, okay, all right, let me have the team around so that we speak to, then I'm doing it on their behalf.
Okay.
So doing it on your own will not fall under 84 to 84 2E,
2E. Right.
because you are not acting on behalf of the team, and you
Okay.
are not acting under supervision of the team.
Okay.
And so some people, as you said, may be affiliated to people or may have associations with people, and others will come to them for A or B of clarification.
Mhm.
But you knowing that you are whatever you are going to do, you don't have the permission of the person on whose behalf you are going to speak, then you have to put the person on notice that this is not advice. This is what I think.
Okay.
Then you exonerate yourself from 91, which will be an offense to give such advice.
Okay.
Then another example, um, somebody who works in the premises. Let's say we have, when you come to BWF, for example, we have our um, our front desk managers, reception team. Some people will call and reception team will offer some clarifications.
Mhm.
When they are doing that, they are doing it on behalf of. And so they come under, for example, 84
2E.
2E. But if they have finished for the day and they go home and
Yeah.
someone approaches them and they think that because they have the aroma of the premises, so they are giving it at that point, that will not be on behalf of, and that will not be acting under supervision, and the person will not fall under 84, and the person's behavior will be an offense under 91.
So in this case, then the best advice to give to people who may be privileged to have some knowledge is that one, what I'm giving you is a suggestion. You may or may not take it. Or if in doubt, visit, for example, BWF solicitors because they can give you expert advice so they can confirm whatever it is that I gave you, and upon that, you can make your decision. Would that be appropriate answers for such people to give?
That is the best, because the law says that anybody, it says it is an offense to give immigration advice or offer immigration service.
Mhm.
What is advice? Advice is information upon which somebody will rely
Okay.
to make a decision.
Right.
And if the decision becomes injurious to the person, then we are looking at the proximity between the information and the action or decision.
Mhm.
If the proximity is there, then we say because of this information, that's why the person made this decision, isn't it?
Yeah.
So if it is wrong, who caused it? The
You did
advisor.
because you gave them.
Exactly. And that's why the law is trying to make it clearer. So where you are not sure, in the instances we come to the show, somebody will ask a question, I say, I have to verify. And so at this moment, I will not advise you, but I'm speaking as if I'm a layman telling you what I think.
Right.
Don't rely on that because it is not an advice. When I verify and I come back to you, I'll give you advice. That is giving the person information, but you are not expecting the person to rely on that to do anything. That is not immigration advice. It's just like me sharing information, and I'm still telling you that don't take my word for it. Check before you act on it.
I have another scenario here. The purpose of this program is to encourage people, empower people so they may be able to complete the applications themselves, or uh, have enough confidence to self represent when it comes to probably immigration appeals or other situations like that. If somebody self represents and say that I am doing XYZ, and then it comes to the fore that probably they listened to this program, and based on the information on how they understood the whole situation, they acted. Would they be putting BWF solicitors or myself as the host of this program in the line of falling foul of the law?
That is why we have presenters and we have speakers.
Okay.
When the speakers come on the show, they speak as experts under 84,
Okay.
don't they?
Yes, you do.
And when speakers come who may not necessarily be under 84 A, B, C, then they will fall under 84E. They're acting on behalf of.
Hmm.
So if you are coming to act on behalf of, then you have your backing.
Okay.
In that case, if you are not sure, you won't give advice.
All right.
You say, well, this one, please, I don't have the right um, information at this moment to offer full advice. And so come and let's have a conversation, or I have to verify, or I think but don't take my word for it. In that case, you are putting the person on notice that they shouldn't rely on. So, because when we come here, what are we doing? We are not just having a conversation with the public. We
No,
are
we're educating.
advising them, aren't we?
Hmm. And
That is
advising,
immigration.
yes.
And if the advice is bordering on immigration, it's immigration advice.
Yeah.
So somebody will ask a question, lawyer, blah, 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 blah. They give you the scenario and you say ABC. You are advising them because they are going to use that information to do something.
Hmm.
If it turns out that it is not the case, then of course you have misled the person.
Okay.
But the person is following and listening and using it because the person believes that you fall under 84. But if it turns out that I don't fall under 84 and I gave that information, then I'll fall, my behavior will be an offense under 91 because I'm not qualified to do what I did, and I did.
Okay.
So we are here to empower people, and so we put ourselves on the line that you can trust us and
Hmm.
we can empower you.
Yeah.
We are giving you advice and information. And when you go further, we can even serve you by showing you how to make the application and so on and so forth at a fee. Whether at a fee or not at a fee is still the service and advice.
Okay.
And so when we come here, we are offering immigration advice. And so because we know what we are doing, we know that we have the capacity under 84 to be able to do what we are doing. And we do it within the rules. But we are giving this caution and warning to colleagues who may not necessarily fall under 84 and who may not necessarily working on behalf of or under supervision of people under 84. And because of what they know or what they have experienced or what they have heard, they go on to offer a service under 84. Then that is in breach of 91.
Or 91. So let's go back to 91 for purposes of emphasis to look at what the repercussions are, because yeah, the topic we're looking at this afternoon is to be forewarned, whereby we arming ourselves not to fall foul of 91. So we read the um, bit about restraining order and also had the explanation of restraining order. Lord, I want to look at number 3. It says if an offense under this section committed by a body corporate is proved, A, to have been committed with the consent or connivance of an officer, or to be attributable to neglect on his part, the officer as well as the body corporate is guilty of the offense and liable to um, be proceeded against and punished accordingly. Was it the one you were looking at where I give the scenario that, for instance, I am leading on this discussion? I brought yourself and the other members of BWF Solicitors Legal Group to give the advice and empower people. So then, um, if you
Yes,
misled people, I will be liable and you will be liable to the offense as well under 91.3. Is that correct?
yes, and the 91.3. And 91.3 also extends to councils and what was this one? Um,
Citizens Advice Bureau?
Citizens Advice Bureau. Yes.
Okay.
So Citizens Advice Bureau, they again will fall under free. Councils will fall under free, or any other company. You know, some companies have departments offering immigration support to workers coming from abroad with work visas.
Hmm.
Again, that comes in here.
Okay.
And but the question, who is an officer? So officer is defined under 4. What is who is an officer?
So, officer in relation to a body corporate means a director, manager, secretary, or other similar officer of the body, or a person purporting to act in such a capacity. Maybe 5 will clarify a bit more. If the affairs of a corporate body corporate are managed by its members, subsection 3 applies in relation to the acts and defaults of a member in connection with his functions of management as if he were a director of the body corporate.
Right. So for us, we are not going to go into the technicalities.
Mm,
Body corporate simply means a company or a business acting
yeah.
as a business,
Mhm.
and so on and so forth. So let's keep it simple. We know that within the community there are individuals who may come together to say that we offer immigration advice,
All right.
but they may not even have the license to operate. Then their behavior will come under 91 because it's an offense to do so without license or authorization. There are individuals who do it themselves on their own, and they say yes, that's what they do. They offer immigration support, but they don't have the license under 84. Their behavior, even though they give everything you need, should something go wrong, then it becomes an offense. When it comes to these things, it's always perfect when everything is okay, isn't it?
Mm-hmm.
It's only when something goes wrong, the person didn't get, even here, we come to educate people. But let somebody go and use the form you gave them and it goes wrong. What would they say?
Oh, BWF services said this on their TV.
Exactly. Lawyer
They're going to,
Charles, you told me that I can use form so and so, and I used it. And my visa, they said it is not valid. And so my visa, so what do I do? That is your fault, isn't it?
mm-hmm.
You see, so what we are saying here is this, that even people who are licensed or qualified do so with caution.
Yeah.
How much more those who are not at all? Then, because you are not sure of what you are doing, you may not be able to do so with caution and you give yourself up. But the law is clear that immigration service is a regulated activity, it's a protected service because it puts people in a vulnerable situation. Therefore, when you are offering the advice, then you have to make sure that whatever you are doing, you don't come under 91 to make it an offense. Because once it becomes an offense, then we are moving into the consequence, which is the next stage. What's the consequence? We know that it becomes an offense for imprisonment, right?
Mm-hmm.
That is 91(1) A and B. A says that on summary conviction, imprisonment for a term not exceeding 6 months, and especially where it is magistrate court. But if it's a case that it has to be proven to be so, then becomes on conviction on indictment, and that is likely to be at a crown court, and then you go beyond 6 months imprisonment to 2 years with a fine or one of them. That is the consequence. And so anybody who is member of the public who has been doing this and thinks that, oh, I have the experience to do so, it's only when something happens you become foul of 91. And there's no excuse that I've been doing it all the time. How come? It becomes an offense. Especially when somebody believes that the advice you gave me is not perfect or didn't work for me, and so I am reporting. And once you are reported, especially upon the authority realizing that you don't come under 84, then it becomes a serious matter. Just like driving.
Mm-hmm.
When you qualify with your license and you are driving without insurance, your offense will be driving without insurance, isn't it?
Yeah.
But when you are not qualified to drive because you don't have a license and the car is not insured, double offense. Driving without insurance and
Driving
driving
without license.
without qualification or license. So the same situation here. So if it's about insurance, the punishment will be there. But in your case, where you are not qualified and you give advice and it goes wrong, then it becomes double.
In this case, we know that this update, if we scroll up to the preamble, it tells us that The Immigration Asylum Act of 1999, Section 91, which we've been discussing. Changes have been made and is known to be in force on or before today. That is the 18th of October 2025. I'll ask this very interesting question. Has it started to bite? Has it ever bitten before? Or because it's now being introduced, going forward, it will bite?
Oh no, it's not. It's not being introduced today. It says that this law.
I mean, the changes that have come to this one, that's what I mean.
No, it says that Section 91 is up to date from 1999. Now, whether
Mhm.
there has been changes or whatever it is, it's still up to date. And
Okay,
so, if it is not removed from the law, then it is still
up to date.
effective
Hmm.
and binding. And so, people should be careful. Your second question is, has it ever happened to anybody where the
Hmm.
person has been imprisoned or fined or blah blah blah? We only get to know when the person tells it.
Okay.
And so a lot of people, it may happen to them, but they will not tell anybody. And so even though I will say, no, I don't know, but I will also add that it's possible that since 1999, somebody has fallen foul of
For all
this
of that.
because somebody might have reported certain advice that went wrong to the authority before, and the person has been found wanting.
To be forewarned is to be forearmed, as lawyer Asma has been telling us. He's taking us to the law, he's taking us to some definitional issues, and also generally advised that if you would want to help somebody, just frame your advice in a way to say that what I'm giving you is just a suggestion. It is not binding. If you want to really know what the law says and be so convinced that this advice will work, I'll point you to the right person, organization, or unit who have been so regulated and licensed, and then it can help you to take your own decisions. But me, you know where I'll advise you to go. You know where I'll signpost you to go. You know where I tell you to do is to go to the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. I'm talking about BWF Solicitors, whose advice and advert is next.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. Now, we're still discussing the warning that Lawyer Charles Asma has graciously given us, pointing us to what we could do when it comes to giving immigration advice that will make us fall foul of 91. The 91, Section 91 of the Asylum Immigration Act of 1999. Lasma, just before we went, you mentioned uh, the some scenarios and situations, but I want to be a bit more specific. To um, I have somebody who is making an application for a fee waiver and does not use a lawyer. Now, this person goes online, types in details, form is giving the rest of it. Then the person comes to me and say, "Can you read through this for me and tell me if I may sound convincing?" In a scenario like that, or for instance, people with certificate of sponsorship and they have challenges with all those things and would want to have a quick advice from a friend or the other who may have done it and succeeded. Let's look at those scenarios. How do they fall under 91?
Thank you very much. So 91 does not include those who do it themselves.
Okay.
Because if you are doing it yourself, then you are not giving any advice or you are not giving a service, offering a service to anybody.
Hmm.
You are doing it yourself. You don't have
Oh,
to go to anybody if you can do it yourself. So you are okay. Obviously, if it goes wrong, you are not going to report yourself. So that's fine. But the second part of the first question, where you said that I do it myself and I come to you to review it for me before I send it. The review,
hmm,
is it to confirm that I'm correct?
yeah,
So that if you don't confirm, I won't send it.
kind of.
And that and that upon reviewing, you tell me what is right and what is wrong for me to improve.
Hmm.
So telling me what is right and what is wrong with the form I have filled, would that be advice?
It is.
Yes. Number two, once you help me to improve it and you tell me to send, is that a service?
Yes, I think so.
So offering immigration advice or immigration service whilst not qualified, isn't it?
Yes,
It's an offense.
it's an
You are not
offense. Yeah.
qualified. You are helping your friend out of kindness. You are not qualified. The law doesn't know kindness and wickedness. The law only knows licensed or qualified.
Hmm.
And so, whether you are helping or not, if you are helping, obviously your friend will not tell anybody about it if it goes wrong. But the moment your friend tells somebody that I gave it to John, they will even say, my friend, I gave it to John. And John went through it because he's been doing it all the time.
Hmm.
And he told me that everything was fine. And I actually sent it. And I look at what has happened. That's John's fault, isn't it?
Yeah.
Is John qualified to do what he did?
No.
Does John fall under 91, 1A or B? Yes.
Unqualified. So yes.
And so if it goes to court and it is deemed that this is what happened and it is obvious, John will come under summary conviction with 6 months imprisonment or fine or both. But if John says that, no, how can I be wrong? I didn't have the intention to, then it has to be proven that there was intention to do anything. And that will be the conviction on indictment. And again, conviction on indictment will be those people who will be conniving with all those stuff. So we move on to the second aspect of your point, where companies are doing, for example, fee waivers
Mm-hmm.
for individuals who are switching visas. For example, person is on a skilled worker visa. The person's sponsorship is at risk. The person is switching to something else. And the company will say, no, okay, we'll do a fee waiver for you. We'll do this, we'll do that. The company has taken the job upon itself, even though not licensed to offer immigration advice, to do everything. And eventually, COS doesn't come through. And the person's fee waiver also get to a point where the person has to make the application. And the person is stuck and the visa expires. That is the fault of the company, isn't it? The company will come under 91 because the company perhaps was not authorized to offer such service as to let's do fee waiver, let's do this, let's do that. The same applies to individuals who will say, let's do fee waiver, let's do this, let's do that. So if somebody says that, can you review it for me? If you are not qualified, the best is to say that, I'm not qualified. So I'm not doing it to check technicalities. I'm doing it to check grammar only. So I will check whether the spelling of your name and the things you put there are all correct. And if the grammar is wrong or the spelling is wrong, I will let you correct it. Apart from that, I'm not doing anything else because anything else is technical and that must be done by an expert. Then you exonerate yourself.
Well, it seems that there's a very thin line between suggestions, advice, and let me even put it this way, very thin line between where people stand and falling foul of 91, isn't it?
It is. And that's why, the bottom line is whether the person is qualified to do it or not.
Mhm.
If you are not qualified to do it, always say that this is how I will do it. And that's why those people will usually do it under the person's own name.
Mhm.
Because if you do it under your name will be there, isn't it?
Yeah.
How will you tell that somebody did it for you?
Well, unless it goes wrong and you make noise about it.
For example. But if the expert is doing it, the expert will put their credentials there.
Hmm.
And so it's obvious that expert did it for them. And that's the difference. So
Yeah.
if you're a member of the public and you go to somebody and the person say, I will charge you X amount to do it for you. You tell them that make sure that you put your details there because the question will be, are you being helped or supported by somebody, isn't it?
Yeah.
Then if you claim you are doing it for me because you are an expert or you offer the service or advice, then put your details there so that when something happens, I know who to go to. But if the person says that no, I can't put my details there, then know that the person wouldn't want to take responsibility. That may come later under 91.
Well, if you are doing it and the person is not willing to put their details on there to say that they supported you, then it means maybe two of two things. One, they are not qualified. Two, they are not allowed to do it. So advise yourself. I would advise you to go to BWF Solicitors, fourth floor of Vienna House, 214 to 218 Tottenham High Road, Seven Sisters. They work Monday to Friday between 9:30 and 6 p.m. Call them 0208 493 7340 0208 493 7340, or in emergency situation 077 127 61884. We are speaking with Lawyer Charles Asma. You can also contact him. You can have him on 07947 63 60 37. 07947 63 60 37. Please don't call me because I am not a lawyer. I am just a communication expert. But my lines are active now. You can put in a question or two to lawyer Charles Asma, or you would want to pose a question to the law firm, 0208 493 7345, or you can send a text to 07399208468, WhatsApp as well, or leave your comments in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. And we're going to pick them up. But before we start picking the questions, I want to quickly remind you of my scenario where I gave you something about genuine intention to visit the UK in UK Vista applications. And we said that a genuine intention to visit essentially means that an applicant will leave the UK at the end of their visit, that they do not intend to visit the UK so frequently that they are living in the UK, and that they are genuinely seeking entry for a purpose that is permitted by the visitor routes or making the UK their main home. They must have sufficient funds to cover all reasonable costs. And I heard there's Abamansa, who is a prominent real estate developer in Ghana with properties in the UK and two children in boarding school. She made frequent visits to the UK, sometimes staying for 90 days at a time. She had a multiple visa for 5 years, which meant she could visit the UK at any time. In the last year alone, she visited 9 times, staying for over 30 days on some occasions. On the last visit, she was stopped at Heathrow and her visa was cancelled. So then I'm asking, why did they cancel her visa? He has a 5 year multiple visa, can come in and out anytime. So why was the visa cancelled? Was it because she travels to the UK too frequently? Was it because of her extensive stay on several months on her visits? She is not considered a genuine visitor, or was it because she's likely to stay permanently in the UK? So, having said that, let's go to the platforms and then pick up the questions that you have brought in with Lawyer Charles Asma on standby to help us answer them. We had one from one of our very good friends from the very beginning. We'll be coming to that. I think we can start with that. Baron, yes, he says, I'm a son of a British father and I want lawyer to apply for citizenship on my behalf to the Home Office. Baron, you're a son of a British father. Maybe I would ask, based on some of the scenarios we have had before, when you were born, was your father settled and had a British citizenship, or what? Maybe that will help. But well, Lawyer, could we proffer some advice for our friend Barry?
Yes, we can offer advice that fall under 84. Okay. Yes. Yeah, I think Baron is just saying that I need help. Can a lawyer help me? Yes, Baron, we can. Please contact us via the telephone contact and we'll be able to assist you after we have discussed in detail your request.
Okay. Right, Baron, 0208 493 7340, and we can help you with that. Danny Woods says, good evening. Yes, good evening. I want to kindly ask Lawyer Charles if certificate of sponsorship can be verified if issued to a person. So when somebody issues you with a certificate of sponsorship, how do you verify it's accurate and it's genuine?
Right. So there's something called presumption.
Mm-hmm.
Presumption means that on the face of it, we don't have to doubt it. And because there's presumption that this is a genuine certificate, there's no opportunity to doubt it. And so there's no avenue for verification before use. Your job is to make sure that when you are getting the certificate, you are getting it from the right people so that there will be no need for you to verify because the presumption is that it's genuine.
Presumption. But those of you who have certificates, please don't issue wrong ones and fake ones to people because you put them in dire situations and you could end up in trouble as well. So do it right. Well, let's pick up the next one, and we have one from Alexandra. Please, in regards to the certificate of sponsorship, how many years would it be for the person to apply for a permanent residency here in the UK?
Right. So the starting point is 5 years on the sponsorship certificate or in that employment 5 years as a skilled worker. 5 years.
Okay.
Obviously, once your 5 years is up, to apply for indefinite, you still have to meet the requirement that the job is still available, the employer still needs you, the income is still available, and you are going to be paid, and so on and so forth. If the employer can confirm that, then even though 5 years is up and nothing has changed within the law, you may not qualify for indefinite because the indefinite threshold is also clear.
Thank you very much, lawyer. We move on to the next one we have from the platform. Joseph is asking, I'd like to, it says, if I'm a skilled worker and I gain my indefinite leave to remain, will my kids get indefinite leave to remain if I'm applying for them from abroad?
Right. So this is a good question. It's a good question because you see, most people will let their family members, if they qualify, join them before they are due for indefinite.
Mhm.
What if I have I have acquired indefinite? Are my children joining me as skilled worker dependents? They won't join you as skilled worker dependent because the moment you have acquired settled status or you have settlement,
Mhm.
you are not under the threshold of skilled worker.
Okay.
So your children who will be coming later to join you are coming as dependents, children of settled and present, someone who is settled and present in the UK, and that will come under Appendix FM.
Okay. So Joseph, yes, that's what it is. Thank you very much for asking, and we so grateful that you follow this program. We're live on YouTube and Facebook at BWF Solicitors and at BWTV UK. Kojo is asking, if you get indefinite leave to remain through retained right, do you still have to wait for 1 year before applying for British passport? Maybe I would correct it and say before applying for your naturalization, which would lead eventually to getting your British passport if you so wish. Yes, Lord.
The answer is yes. You have to wait for 1 year because it falls under Section 6, Schedule 1 of the British Nationality Act of 1981. So you have acquired settled status or indefinite leave to remain. You hold it for 1 year because this is not one of the exceptions. Exceptions would be that you were married to a British citizen and you were granted two and a half for 5 years, and you have done your indefinite. The moment you have your indefinite leave to remain, you can apply for citizenship. That is different category. You were a husband or a wife of a British citizen, and you were under Appendix FM visa for two and a half. You have done 5 years. You have gotten the indefinite leave to remain. The moment you have indefinite leave to remain, you can apply for naturalization. In your case, you are not like that, so you have to wait for 1 year.
Yes, my friend, you would have to wait for a year. If you want to join us on phone, the line is active 0208 493 7345. You can send a text or WhatsApp to 07399208468, or you can leave your comments in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. The next one here is from Francis, and he's asking, can a Ghanaian man marry a non Ghanaian woman through proxy marriage in Ghana?
So the question is simple. Can two people resident in the UK marry in Ghana under Ghanaian customary marriage provisions?
Mm-hmm,
Now, what because the person said non-Ghanaian woman, when it comes to custom marriage um, provisions,
mm-hmm,
both of you are not going to be present, and because both of you are not going to be present, you need your families to represent you.
mm-hmm,
The question, that non-Ghanaian woman Does she have families in Ghana to represent her? If yes, then just like yourself, you'll be represented. If no, who will represent her so that the registration can take place and for the ceremony itself to be valid?
Okay. Then let's see who else has another question for us, and it's from Kwame. I made 20 years private line application and it's 17 months now. What do I do?
All right, Kwame, keep doing what you are doing. I'm sure you've been sending them messages, emails, so do that. Now, even with the pre-action protocol letters we send, it's like it's losing its purpose because they don't really mind so much.
Mm.
So what I've been telling my clients now is to get the MPs involved, and some of them that have gotten the MPs involved are getting responses that the MPs are pushing with emails here and there, and there's one who has actually been granted after the MP's involvement together with myself, and so Kwame, I would say get your MP involved. 17 months is long, even though it's happening now, so that the MP can assist with the push.
MPs can assist with a push. BWF solicitors will help you signpost you to the right places, and you can rely on their professional services. Call them 0208 493 7340. Let's take another question. It's from Becky and it says, please, I'm a dependent and have been given 60 days, which will end on the 11th of August. That's past. But I've made an application, but my biometric date is on the 14th. Please, won't my visa be cancelled? Okay, let's use this as a scenario. For instance, we have somebody who's been given 60 days, which will be expiring in the next week. And by the time it expires, the appointment they are giving is 4 or 3 days beyond the time it would expire. What will happen to such a person?
So the biometric appointment will only make the application valid
Okay,
so that the caseworker can go ahead and make a decision. It doesn't mean that there is no application.
okay,
The application is the starting point of the whole process. And once you apply, whilst your visa is still valid, we say that you had exam leave. And if you had exam leave and you applied, you are protected under Section 3C of the Immigration Act of 1971. Now, the rules say that make sure you enroll your biometrics within 35 days. So it's not a big deal if you didn't get appointment early. If you got an appointment after the visa has expired, it doesn't matter. You applied before the visa expired, and that is what is important.
okay. Right, we'll take one more and then come to look at our quiz and then draw the curtains down. Can someone who's still in Ghana as a teacher come here by COS, or they are part of those who are banned from July 22, 2025?
Teachers are not restricted, only carers are
Okay,
restricted. So if you're a teacher, you're a nurse, you're a plumber, you're a construction worker, all those other categories are open. So if you're a teacher, you are not just coming, you come to work. So make sure your employer has agreed with you that they are sponsoring you and they give you the sponsorship certificate to go get a visa. And if that is the case, you are okay.
if that's the case, you're okay. And if it's the case that you are relying on BWF solicitors, I know you're okay because you will be given the best advice and also signposted to where you need to go. And I would also want to encourage you to stay with us every Saturday afternoon between 4 and 6 p.m. UK time, where we have the community and the law. We have the chance to discuss all issues immigration, all issues law, and we bring up a topic that is so pertinent to our situation within the week or within the community. And we get lawyers from BWF solicitors to help us address those ones like we have done today. Forewarned is forearmed, and we have looked at the caution to unlicensed immigration advisors in the UK. And now I gave you the nugget about a genuine visitor situation, and we talked about who a genuine visitor is and what it is that you need to do. They said you must have sufficient funds to cover all reasonable costs. Then I gave you the scenario of Abba Mansa, who is a prominent real estate developer in Ghana with properties in the UK and two children in boarding school. She made frequent visits to the UK, sometimes staying 90 days and over at a time. She had a multi visit visa for 5 years, which meant she could visit the UK at any time. In the last year alone, she visited 9 times, staying for over 30 days on some of the occasions. On the last visit, they stopped there at Heathrow Airport and cancelled their visa. So then I'm asking, what could be the reason for the cancellation? Is it because she travels to the UK too frequently? Is it because of her extensive stay of several months on her visits? She is deemed not to be a genuine visitor, or because she's likely to stay permanently in the UK, they said, nah, go, go, go. We give you a visitor's visa. And that's about it. What do you think? Think about that. Give me your answers as Gabriel has done. Number two, Gabriel says because of her extensive stay of several months on her visits, she's not a genuine visitor. Kwamia also thinks same because of her extensive stay of several months on her visits. Kwamia said thinks because she is likely to stay permanently in the UK, so they say, stop. We nip it in the bud. Okay, a stitch in time, we saves nine. Um, Eric Osei thinks number two. Thank you, Eric. Richard Dia says number three because he's like to stay permanently in the UK. They are stopping that. Linda Crunchy also believes that it's number three because she's likely to stay permanently in the UK. Francisca says no because of her extensive stay of several months on her visits. She is not a genuine visitor. So thinks Erika Abwaje. Who else has an answer for me? Ishmael thinks it's number two as well. Thank you, Ishi. And the next one here, Emmanuel said, because she's likely to stay permanently in the UK. Number three, he says, and they have stopped her. Helena J is saying that Abamansa has had her visa cancelled because she travels to the UK too frequently. Mami Dufie says number two. Thank you, Mami Dufie. Next is Edward Mensah, number one, because she travels to the UK too frequently. Emmanuel Tavia says number one. Ima, thank you for your response as well. Moses J thinks it's number three because she's likely to stay permanently in the UK. And I take that very last one from Eric Mensah, and Eric Mensah says it's number two because of her extensive stay of several months on her visits. She is not considered a genuine visitor. Well, let me go to. I was like, okay, let me not fall foul of 91 and stay under 84E. Lawyer, what could be the answer?
I like the way you are applying the law. I want to stay under 84 AE. Yeah. Because you're acting on behalf of a firm that is licensed to do so. Awesome.
That's right. Yeah.
Okay. So under paragraph V 4.2 of Appendix Visitor to the Immigration Rules, and the case of R. Ezev, Secretary of State 2024, we are told that the visit should not be frequent and they shouldn't appear as if you are living in the UK as opposed to visiting the UK. We see from the fact pattern that she's been visiting in the last month alone nine times, and before the last month alone, there were other times she was coming in and going. And most of the time, 30 days, which is 1 month before she leaves. So if we are looking at average of 30 days for 9 times, that's 3, 9. So that's about 9 months, isn't it?
Mm-hmm.
Out of 5 years. So if somebody is living in the UK continuously for example, or altogether appears close to 1 year within that short space of time, would the person be seen to be a visitor or be deemed to be living with us generally?
Generally, for 9 months on end, we can see you
It
here more than a
appears
month.
that the person is with us as
Yeah.
opposed to coming to us, isn't it?
Yeah.
And so That is the presumption that you are not a genuine visitor because of the extended stay of several months on the visit. She is not a genuine visitor. Answer is two.
Lawyer says the answer is two, and as he has explained, is because through her frequent and successive visits, she was not seen as a genuine visitor. This was in light of the amount of time she spent in the UK. And as we know, the core principle is that applicants must satisfy the decision maker that they are a genuine visitor, intending to leave the UK at the end of their visit and not use the UK as their main home. Remember, we used the case of Eze versus the Secretary of State for the Home Department, and it's a Judicial Review 2024 case. So those of you who said two, you are correct. One and three, no, I'm afraid. Thank you very much. And with that, I drop the line back to lawyer Charles Asma to give us a summary of the warning he gave us at the beginning of the show.
Yes, thank you very much. Ladies and gentlemen, today this is what we looked at. We put the spotlight on those who give advice on immigration in the UK and actually help people with immigration work without qualification or license to do so. And the assurance to the public is that if anybody does that, they have committed offense. And so you can take them on. If anybody has taken your money to do something for you without that authorization, they have committed offense. You can take them on. The person's promised sponsorship certificate to get you a visa and all that, that is offense. The person helped you with your application, took some money, that's an offense. Without license, that's offense. And all these things, the law says that you have a right to complain for you to seek redress. And for those people who do that, you've been doing it for some time now, this is the time to put a stop. Otherwise, once caught, you come under 91, Section 91 of Immigration Act of 1999 with specific reference to 1A, which is conviction on summary conviction, 6 months imprisonment. That is at magistrate court. Or if it goes further to prove that indeed it was an offense you've committed, then that will go further to 2 years imprisonment. Either way, you can even have with a fine or have it alone. Forewarned is forearmed. A stitch in time saves nine. A word to the wise is enough. Good evening.
A word to the wise is enough, and I will say a word. Visit BWF Solicitors, and you will be happy you did. It's been another wonderful edition of the community and the law brought to you by BWF Solicitors, a trusted partners when it comes to the law. So, everybody, on our own behalf, let's come together and say thank you to Lawyer Charles Asma for his time this afternoon, for his patience, and of course, grace to deliver on the topic. And to the BWF Solicitors family, we say thank you very much for the opportunity every Saturday. We're coming back same time next week. And I want to also comment those of you who watched with us and those of you going to watch later on to say thank you. So Sheila, Tilly Dema is not coming up with her answer. Anyway, that's so interesting. It's true. Yes, that's correct, Tilly. Thank you very much. So on behalf of Sheila Ankra, Padmo Dodu, and my producer, Professor Ade, I'm Kweku Owusu-Frimpong. Thank you for watching. Good evening.